All right. Hey, everybody. This is Tatiana from BlkArthouse. Today, we are joined by Sammetria Goodson, and she's going to talk to us about art contracts for artists and negotiation. So this is something that is really important for artists and Black artists in particular, as you are working with galleries, museums, exhibitions, any kind of institution in which you are displaying your artwork. This is really important so you aren't taken advantage of, and you're able to have a favorable outcome for how you're interacting. So without further ado, Sammetria, take it away. Thank you.
Absolutely. Thanks so much. And again, thanks for the opportunity to share with you guys here at BlkArthouse. So I'm sharing my screen here and I'm going to go ahead and get started. Can you guys see that? Can I get a thumbs up if you can see my deck? Art Contracts and Negotiation, presented by moi. So my name is Sammetria Goodson, and I am the managing attorney of my own firm that's based in and has a presence in the DFW Dallas area because I'm licensed in Texas, and also in Philadelphia as I am licensed in Pennsylvania. So my firm works almost exclusively with artists, creatives, designers, makers, folks who are monetizing creativity, who are supporting themselves with their creativity. And I help them start up their ventures, protect their work, and also grow sustainable creative businesses and art practices. That spans art and entertainment. It also involves fashion, beauty space, lifestyle brands. I represent influencers, all of those folks. And I do primarily what's known as transactional work, which that's a term, another fancy way to say contracts, but transactional work. But I do have some litigation experience. So to the extent that there's some sort of issue and we need to do something about it, I have experience with resolving those disputes, hopefully before they go to some sort of like court proceeding. A little bit about me. So you know that I'm an attorney. I'm also an art lover and an artist, advocate, and a collector. Born and raised in Houston, went to school in Austin, lived in Cali for a little bit, lived in New Jersey for a little bit, in Philly, and then I moved back home to Texas. So I'm based in Dallas. Background, formal education would be business and marketing. So I double majored in business and at the University of Texas at Austin. So I've been straddling the world between business and art for a very long time. It's what I went to school to study, to try to work on the intersection between the two of those disciplines. And I also have experience working in marketing and sales prior to going to law school. So actually a lot of the way that I negotiate contracts is informed by the fact that I was in marketing and sales and negotiated contracts from a different perspective way before I went to law school. Went to law school in Temple in Philadelphia. After that, I clerked for a judge. And in that court, we dealt with motions, which are like preliminary court documents, but I saw a lot of contract disputes. So one of the things that I also lean on is the difference between what's on paper, what people think contracts actually say, and then what happens when you have to try to enforce those contracts in court. So that comes from my experience clerking, but then also my litigation experience, and then what I do on a day-to-day basis in contract negotiations. So that's just a little bit about me. This screenshot from my website. Definitely reach out to me after this if you have any questions. But I wanted to start with a little bit of background so we had like some context, or you guys had some context about the perspective that I'm coming from, and how I work with artists to help make sure that they're not exploited on a day-to-day basis. I will mention though that I do work with all participants in what I call the art ecosystem. So that the way I describe it, that means I work from studio wall to collector wall. So I represent artists, I represent galleries, I represent art consultants, I represent folks that are on like more the commercial art side. I represent collectors, I've represented collector groups. So I'm representing people across the board, but the majority of my art law practice is geared toward protecting artists. So this presentation will be from an artist-centric, pro-artist perspective. So real quick, these are topics of discussion, roadmap for our time together this evening. I just did the introduction and background, so we'll move on to number 2, which is an overview of the legal system and how contracts fit into the system. what I have found to be the most helpful thing for an artist is when they understand the macro view of how the legal system works and where contracts fit in, because it just kind of expands their mindset or expands their understanding of where their little contract or where their little deal could fit into the broader conversation that's being had with managing relationships. We'll go over the anatomy of the contract. So I will give you like the legal view, like what is actually enforceable in court for a contract. And then I'm gonna contrast that with some of the things that people think about contracts as communicated to me from clients or even communicated to me from parties on the other side. Then we'll drill down. So we'll take macro view and we'll drill down to the micro view. What are some of the types of common art contracts? We'll talk about negotiation. And then I have just a quick little, I think it's 3 bullet points on simple ways to protect yourself. And then we'll open it up to questions. So let's start with an overview of the legal system. Artists often don't realize that they actually have many different sources of rights that are currently existing in the laws that we have on the books, like law as it currently exists right now. There are like multiple areas of the law and multiple intersections that artists avail themselves of in order to protect themselves. Constitutional law is one of those areas. You have the federal constitution, and most, if not all states have some sort of constitution or governing document at the state level. Texas has one, Pennsylvania, the Commonwealth has one, Pennsylvania has one. You also have statutory law. These are laws that are passed by either Congress, the legislature on the federal side, or your individual state legislature. You also have common law. Common law is a law that's created in the courts on a daily basis. Essentially, every time a judge makes a ruling, technically common law is being made, but common law is very important, as we'll see on the next slide, to the interpretation of contracts. And then we have contractual law, and I have that kind of starred because that's what we're going to focus on here, but I put it as contracts oftentimes are as important to any statute that's passed, right, the federal or state level. And contracts definitely intersect with the rights or protections that artists have at the federal constitutional level. And oftentimes when there are disputes, when things go kind of sideways, those contracts aren't interpreted by courts. So again, it's very important, I believe, to understand that as an artist, there are various aspects of our legal system that can be utilized, there are levers that can be utilized to protect an artist in their transactions. So to kind of drill down into these various areas of the law, what I've done here is just kind of put a bunch of different things on the slide, not so much that I'm going to go over each one, but I just wanted to visually represent like the totality of and the breadth of where artists' rights and protective aspects of our legal system exist for artists. So for constitutional law and statutory, federal, we know that's copyright and trademark. So we'll drill down into copyright a little bit later, but the primary source of constitutional and statutory law that is helpful to artists sits with copyright, and then trademark is becoming more important over time. State law is also, though, very important. There are laws at the state level that protect property rights, and physical pieces of art are considered property. You have trust in the state's law. This protects artists' legacy. You'll hear me say the word legacy a couple times, but that's to do with wealth creation, legacy building, and making sure that your estate as an artist is sort of set up in a way that can benefit your family going forward. That typically sits at state law level. You have organization law. Organization law is a set of laws on the state level that protect things like limited liability companies. It's like the source of the business law in a state. And you also have art-specific law at the state level. The 2 states that have the most robust art-specific, like art-related law would be, you can guess, New York and California. However, there are many states, like the state of Texas and the Commonwealth of Pennsylvania, that also have laws that are specific to art transactions and art contracts. I can't tell you how many times I've even negotiated with galleries who don't realize that their actions are governed by the state law that deal with art sales in their state. And I've had some interesting conversations with galleries who are trying to negotiate for things that the law in the state prevents them from doing. So constitutional law and statutory law are important. Common law, again, has to do with the law that's in the courts. These are laws that are the source of law and the source of really relief for artists that comes from court decisions. I want to introduce you to a term called tort. This is a word that first year law students become familiar with like on day number 2. But the concept of tort is that there are laws and there are court cases out there that talk a lot about how people interact with each other. And there are standards of care. There are things called fiduciary duties. There are ways that our societies say that we're supposed to interact with each other. And oftentimes, when something goes sideways, you're not necessarily relying on the contract for relief, but you may be relying on this other form of what's known as tort law in order to get some sort of a favorable outcome in a situation where something has gone haywire. So that's typically exists at the state level, but it's definitely the type of law that's created when courts are making decisions and they're applying these standards to cases. Courts also interpret statutes, both federal and state law. So again, there are favorable, just like there are art-specific states that have a lot of art-specific law. There are certain circuits in the United States where the judges have more experience dealing with art-related and intellectual property-related cases. So Second Circuit, Ninth Circuit, even Fifth Circuit, which is where Texas is located. Third Circuit is where Pennsylvania is located. So there are certain circuits in the country that have more familiarity with certain types of legal issues dealing with artists. And you have contract interpretation. So moving very quickly over to what I now have called self-created law. This is AKA contractual law. And here's the point. Contracts are your own law. Self-created law means that whatever is in the four corners of that contract, whatever the agreement is, that's basically your opportunity as an artist to come up with your own rubric, your own law for how that relationship will be managed. You'll hear me say this later on, but a contract really isn't what I call like a magical sheet of paper. It's not just like a sheet of paper with words on it. That contract is like you creating your own protocol, your own procedure for how the other person is going to interact with you and how they're going to treat you. What's also important to know about contracts is that they're so important to the underpinning of our economy and society in the US and other places that a court will enforce your law, right? So if you come up with something in a contract, barring something that's just like completely outside of what could be enforceable, the court will enforce what your agreement is with the other side. And so again, the contract is supposed to represent the decisions you've made with that particular party on the other side. They're not just pieces of paper with words on it. It's your own law. Knowing this is very empowering for an artist when you kind of see it that way. This is just an overview of some of the main terms. You have the parties, you have the dates, you have what is the exchange of services, you have payment terms, you have the terms for breach. So when you think about contracts, it's not if something happens, it's when something happens, what's the procedure for dealing with it? And then you also have documents called change or scope documents. This becomes becomes more important if you have like commission agreements, for instance. So there's like the macro view, overview of the sort of various areas of our legal system that already provide protection for artists. So let's go over some myths, right? Here's some contract myths. Number one, they're for the rich and famous celebrity artists. So that's one that I get all the time. Like, oh, the only people doing contracts are the ones who are like, selling at a certain dollar amount, or they're, represented by certain galleries. Those are the only artists that need to think about contracts. So that's a myth. In a minute, I'll show you like literally why it's a myth legally. But that's a myth. Contracts are not just for like the rich and famous or people that have money, which go into point number two. Some people think contracts are a waste of time and or money, or just a luxury in that, they really don't have any power. There's like some of the artist mindset. I don't have any power. I can't enforce it. These people have more power than I do. It doesn't matter if I have a contract because they're going to do what they want to do anyway. Or well, I don't have a lot of resources, so it doesn't make any sense for me to try to get help with a contract because I don't have any resources, or it's considered like a luxury. Again, it's like something that you just do when you have like a lot of resources, or if you're, selling work at a certain, dollar amount, then the contracts become important. So that's a myth. Number three, contracts are a hindrance to getting paid. This is one that I run up against all the time. A lot of people see contracts as the thing that keeps them from getting the money. So they have a conversation, the business people, and then like the sheet of paper shows up somewhere, and that sheet of paper is like symbolizes the thing that's keeping them from getting paid. So they see the contract as like a hindrance. It's not something that is helping them. They see it as something that's hurting them or keeping them from getting paid. So that's a myth. We'll talk about why that's a myth in a minute. And the last thing is I already kind of teed it up. A contract is like a magical sheet of paper. So one example of that would be, oh, well, I just need to grab something off of Google, and then I'm going to print that out, and then I'm going to have the other party sign it, and then that's our contract, right? It's a magical sheet of paper with words on it. It doesn't matter if the words have anything to do with your particular deal. The fact that it exists provides some sort of protection. Like its existence itself is magical and it's going to provide protection for you. So that's a myth. As I mentioned beforehand, the contract should actually be, it's your own relationship. It's your own self-created law. So it should be something that's specific to what you're doing. So those are some of the myths. So what are the myths busted, right? What are contracts actually, like a way to think about them? So if we want to shift our mindsets, we can think about contracts as a source of protection against power imbalances. And that's a major point. At any point in your art career, I don't care how much, I don't care how much your art, like the dollar amount of, or the sticker price of your art, there will be a power imbalance for various reasons. And so oftentimes the contract, and I will say explicitly, the process of contracting, the communication, the negotiation, the questions, some of the process I'll walk you through later, that has value because it shifts that power balance. You may be like, in your mind, the smallest artist ever against like a big major corporation, but the way in which you enter into an agreement, the conversations you have, the questions you have can bring a little bit more balance into that particular relationship. And it starts with how you negotiate, but contracts are a source of protection against power imbalances. Sometimes artists don't perceive the power imbalance. They make a miscalculation on the other side, with a party on the other side. And so they think, oh, the contract, I don't need a contract because we're equal. So not one person over the other is not going to take advantage of, each other. But sometimes it's just a miscalculation. So there's typically, a power imbalance when you have, parties coming together into some sort of agreement. Contracts are also a means of managing relationships. Again, it's within a contract, you could actually set up a procedure for what happens when things go sideways. What happens when there's a termination? What happens when the money is not paid on time? Or what happens when something happens and you need to delay the deliverable or the work that you're doing on a commission contract, for instance. It's a means of managing relationships. Contracts are very useful for establishing long-term relationships. What I mean by that is if you develop a posture of incorporating contracts into your art practice early, even if they're very simple contracts, the way that you began working with individuals definitely impacts whether or not or how you can expand a relationship later on, because you're basically establishing a course of dealing with the other side. So what I found is that my clients who actually attempt to negotiate, no matter the size of the project, by the way, their approach to the conversation helps them later on, and they actually establish themselves as more of like having more of a business mind or being lower risk for the other party because they're actually asking questions and trying to negotiate. So it's useful for establishing long-term relationships. And they are used in the art ecosystem. So I had to put an asterisk here. I often hear mostly from the party that perceives themselves to have more power. I hear, oh, we don't do contracts. Oh, it's just a handshake thing. Oh, we have such a great reputation in the industry and we don't do that. So often you'll hear that, or I typically will hear, oh, well, we just talked about it and it's not that big a deal. We really don't need to get into some extended contracting process. So my point is that there's a difference between a 50-page agreement for something that, is not necessary to have that, versus even something such as like a well-drafted email that has the contract language in it, just so everybody's on the same page about what we're doing. So contracts are used in the art ecosystem, but sometimes they come in forms that you don't really recognize. So what is a contract, right? So we're shifting to the anatomy of contracts. The legal version, like what lawyers look at, what courts look at, they're looking for these elements, is what we call them, to enforce a contract. You need somebody making an offer of something, another party has to accept that offer. There's this thing called consideration, meaning there's some exchange of some sort of value for the contract. You have mutuality, meaning that the parties are able to come to the table kind of equally. There isn't some sort of issue with like someone being underage or someone not having the mental capacity to enter into an agreement. So there's mutuality, and that also bleeds into capacity, right? Having the mental capacity to be able to enter into the contract. So these are kind of like the things that you need to have what's known as a contract. It's an agreement between parties that creates mutual legal obligations. It's a set of promises in exchange for a benefit. It's an agreement to perform a service or provide a product. So again, back to I'll revisit what I just said. A contract isn't necessarily like a 20-page document. A contract can also be an email, and courts enforce emails. An email that has a description of the things that are on this slide. You're establishing what the agreement is. You're explicitly saying that you accept what is being offered. And then you have some of the terms that we'll talk about later. So I'm sure at this point you're wondering whether or not you can enforce what's known as an oral contract. An oral contract is kind of self-explanatory. It's a contract between people that's just based on words. It's not written down anywhere. So the answer to the question is, yeah, you can enforce an oral contract. The issue is that the cost to do that in court from a litigation standpoint is very expensive. You have to do things like depositions, which cost on average $1,200 a piece, depending on where you are. You have to go through a process where you collect evidence. There's a bunch of motions, which are just points in times where you argue in court. It's very expensive to try to enforce an oral contract. Another question or something you might be thinking is, okay, well, if you could do a contract via email, can you do one via text message? Can you do, a contract via Zoom meeting? These other like forms of digital communication, like text message, Slack, or something like that. And the answer is, well, yeah, you can technically try to enforce a contract via text message in a court of law. But again, the cost to do that is really high. So the reason why you often see things written down is because it is a way to summarize what the agreement is, so that if you need to enforce it later on, it brings down the cost of that, and you can, be one step closer to some sort of relief. So that's the legal side. That's the legal side of what a contract is, like what we look for when we are trying to enforce contracts, and certainly what a court will be looking for a contract, for a relationship that has gone sideways. So essentially, it's what exists after you come to an agreement. I stress that point because one of the things I see almost every week is an artist who's had a conversation with, let's say, marketing team or whoever, and they have a bunch of things that they've been talking about. And then after that, they get a sheet of paper sort of like shifted to them across the desk, if you will, the virtual desk. And that sheet of paper does not have in it the things that the artist talked about with the business people. And so it's very common that the party that has more power will treat the contract like that. Like it's just something that you signed, and it's just legally, it's just boilerplate. It's just something that we have to sign to get to the next step, like to get the invoice out. And none of what was discussed in the meetings ends up in the final document. So my caution here, back on the last slide, is what the contract really is supposed to be, what is enforceable in court, where you will have the most protection as an artist, is to make sure that the final document that you're signing actually reflects what you've discussed with the party on the other side. So when I'm talking to artists, I often will start with getting an understanding of kind of how they think about their practice. And often their practice falls into a couple buckets. One is the fine art bucket, one is the commercial art bucket. The difference between these buckets, and there is overlap, but this is kind of like a framework to think about your artistic practice. The types of contracts you enter into on the fine art side and the way that you negotiate and the things that you think about are all meant to make sure that you protect the market for your fine art, like your individual works of art. And there's certain ways that you can negotiate or certain things you want to be on the lookout for if you want to preserve that particular income stream, if you will. When it comes on the commercial side, it's more like licensing. There's certain works of art that you, for instance, only license and you don't consider those to be fine art. There are certain pieces of fine art that you would never license because it can negatively impact the value in the market for the fine art. So if you are an artist that kind of straddles both sides, you do some licensing agreements, people have approached you to maybe use some of your images on like merchandise or certain products, you want to think strategically about how your art is used and what the impact can be on your particular markets. They're different income streams. So the first thing I do is typically work with the artist to try to get an understanding of how they're viewing their artistic practice and the type of like agreements and deals they've entered into, prior. Another way to think about your art contracts is you have internal contracts and external contracts. Your external contracts govern your relationships that are outside of your own house, if you will. These are like gallery contracts. They may be contracts, even someone that's commissioning a work from you that's like an external contract. Your internal contracts govern the relationships with your team. So to the extent that you have a studio assistant or you hire a photographer to take images, high definition images of your work, you have a social media person, a PR person, those are all internal contracts. And those contracts manage your internal relationships. So that's another way to think about it. A third way to think about your art contracts is time, right? You have some deals that you do that are more temporary. An example would be you do an exhibition agreement at like a alternative pop-up art space, like a coffee shop or something like that. That has more of a temporary shelf life for the things that can go haywire in that deal. So it has more of a temporary focus versus the type of contracts that are more legacy building, like the ones with major institutions or contracts for commercial art where you're doing multiple works of art over a period of time. Those have like a longer shelf life and the amount of time it takes for issues to arise is extended. So the way that you approach those more like legacy building contracts from a negotiation standpoint is different than how you negotiate something that has more of a temporal kind of basis to it. So these are kind of like the frameworks when I'm working with artists. We kind of take a look at all of what they're working on or even that particular deal, and we try to orient it in a framework that's similar to this so that we can get an understanding of what needs to happen for negotiation. But essentially it's all managing risk. That is a lawyer-based like legal way to think of it, but I want to introduce that to you in the idea that you're managing the risk of something going haywire. You're managing the risk of someone taking advantage of you. You're managing the risk of somebody exploiting you. And so thinking about that particular contract in light of all the things that we talked about up until this point is helpful in doing that, in managing risk. So to go over some contracts that you may encounter at various points in your artistic practice, I just kind of wanted to run down the list. This is typically the order is roughly the order that you'll start working on different contracts. I tend to, when I'm working with clients, I tend to kind of abandon the emerging artists, mid-career artists. I tend to abandon those labels because there are artists who've been working for decades who may just be getting in the commercial art side of things. So essentially they're just starting out when it comes to commercial art. So to me, it's more helpful to think about it this way. But when you're just starting out, typically the first thing you're going to do is sell a work of art, right? So you have an art sales agreement. Typically, if there's a gallery involved, that agreement will be something that the gallery has with the collector, but there's an art sale agreement. It's also known as a bill of sale. it's kind of like a title, if you will, for the particular work of art. But that art sales agreement controls and has contract terms related to, most importantly, copyright, reproduction. It kind of controls what the collector can do or what the collector's responsibilities are for that particular work of art. I did not put on here a certificate of authenticity. I didn't, put that on the slide because that kind of functions differently than what an arts contract or a bill of sale does. It has a different function. The authenticity helps with provenance. It's just something that you need to provide when you sell a work of art. But the bill of sale actually is important. And often what I find is that the artist will give a certificate of authenticity, but they don't have a bill of sale. So that's the art contract that's typically missing in the transaction. For lower dollar amount sales, that may work, right? Because the risk of loss, the risk of something going haywire is lower. But for the higher dollar amount sales, you start to see a little bit more of these bill of sales in the actual sales agreement for the art itself. Then you go to artwork commission agreements. That's typically another one that you'll encounter when you're just starting out. That's someone saying, hey, I really like your work. Can you do something specific for me? That's a specific agreement. And really the terms that are important there are the terms that control how the approval process works for the commission. Because the whole point of a commission is the artist is making something and then the party gets to say, I like this, I don't like this. This fit what I thought it was going to be. This doesn't fit what I thought it was going to be. And so having a procedure about approvals and what happens, and then also controlling when you get paid, like money up front, money for progress, money at the end when you deliver the work of art, those things become really important in something like a commission agreement. Why? Because inherent in the commission agreement is the opportunity for someone to say that they don't like your work. It's not a work that already exists. So you have to manage the risk of that. Exhibition agreements, right? That could be for non-traditional spaces, right? Like pop-up spaces versus like a gallery or a space that's used to having art in the space. If you are doing an exhibition at a pop-up space, you want to look out for the terms that deal with insurance, and you want to look out for the terms that deal with damage to the art, and you want to get an understanding of like the security for the art. So there are situations that I've dealt with when art was exhibited in a non-traditional space, and the legal issues had to do with the fact that the coffee shop is not in the business of exhibiting art. And so the legal risk wasn't managed properly when it came to insurance and the client in this particular situation. One of their pieces of art was stolen, and the other one, the work of art was damaged. But because the contract didn't have anything specific to those issues, there wasn't that much that the artist can do. So the exhibition agreements are important in terms of where the art is exhibited. And then limited representation agreements, these are typically gallery or consultant agreements. And the idea here is that you'll typically enter into a limited relationship. It's your first major relationship, but an artist will enter into a limited relationship where someone like a consultant will say, hey, let me work with you to sell some of your works of art to a specific set of collectors. Or you'll have a gallery say, hey, let me let's do like a hybrid exhibition agreement, and then I represent you for 3 months after the exhibition. So it's kind of like there's a limitation on the amount of representation, but that's one that you typically encounter when you're starting out. And let's say you're expanding your art practice. This is where your internal agreements start to become more important. When you're hiring photographers, social media people, PR, and yes, artists are doing this, studio assistants, any of those people, those are people that are on your team. So making sure that you have an agreement with those individuals specifically for confidentiality. If you have a studio assistant, right, you might have some kind of process that you've developed that is a trade secret. It's a form of intellectual property, so you want to protect that. Or if you're working with a photographer, you want to make sure that you actually have the copyright to the photo that's taken of your work. So just because you pay a photographer to take a photo doesn't mean the copyright in the work. That is how copyright functions. And that's something actually that a lot of artists don't know. So having agreements, your own internal agreements when you have relationships with people on your team, that becomes more important as you're expanding your art practice because you're hiring people, you're engaging with people to help you with your work. Large scale commission agreements, that's either in quantity, someone says, we want you to do, an example would be like portraiture. We want you to do like multiple works of art or a very large scale work of art, from a commission basis. Tend to start to matriculate after you've had your practice for a while. And then another example that would be municipal contracts, murals, things like that. You're just sort of increasing the scale of the types of commission agreements you're getting. You start to get more into the commercial art licensing agreements as well. Again, it's not like a cut and dry distinction between fine art and commercial art, but when I say commercial art, think of licensing. This is where someone is approaching you and saying, hey, I really like that work of art. Can I put that on a t-shirt? Or can I put that on a mug? Or can I use that for some other reason and I'll pay you a royalty on it? Or can I use it to incorporate in some other medium and sell that work in that medium and pay you royalties? Those are licensing agreements. So you start to see more of those as your practice is expanding. And then you start to get into full representation, right? This is where a gallery approaches you and says, hey, we want exclusivity. We want to represent you like all over the world in perpetuity forever. That's typically what they start with. But the full representation agreement of a highly nuanced relationship where you are essentially sort of ceding control over your career, if you will, to an individual or to an entity, full representation agreement. And then I would say this has more to do with a shift in mindset than it does like the size of your art portfolio. But I call this I refuse to be exploited because I'm building legacy sort of zone. This is where everything that you do, no matter the size or who the party is on the other side or what you're doing, that you've made up your mind that you just won't be exploited. Meaning you won't let them tell you, for instance, that the deal is one thing, but then the contract says something else. Or you won't let them kind of tell you that you're not going to have anything in writing, right? So this is more of a shift in mindset. But we're looking at long-term or multiple commercial art licensing agreements. For my clients who are operating kind of at this level, what we are doing is negotiating multiple licensing agreements for multiple aspects of their works of art at a global level. So what we do in one contract with one retailer, we have to be mindful of, like, for instance, the competitors in that space of that retailer. So then when we are negotiating contracts on the other side, that we are managing both the work and we're managing the relationship. So these are like multiple streams of income. These are artists who are monetizing the copyrights for their artwork across like their portfolio. You start to get agreements with international parties. That may actually happen pretty early because of course the world is sort of like flat from a commerce standpoint. But I'm seeing contracts like very early on. Artists who are in shows are getting approached by people outside of the US, outside of Canada and Mexico, who are wanting to work with them. So those are the types of things that you'll see. You definitely want to get some language in a contract like that. Agreements with higher risk transactions, right? Arguably the full representation contract with a consultant or a gallery is a high risk transaction, especially if they are asking for a high level of control over your career for a period of time, more than a couple years. So higher risk transactions. Another example of a high risk transaction is if you're an artist and then the party on the other side is some gigantic company, especially if that company has a history of exploiting people or doing things that aren't necessarily in the best interest of the creative. That's a high risk transaction. So if you know that when you're going into those discussions, it doesn't mean you don't work with them. It just means that you think about the contract differently. And of course, agreements that are aimed at preserving legacy and wealth. These are, again, the types of agreements and terms where you're making sure, for instance, that if you have royalties, that you can assign those royalties over to a trust, or you can assign those royalties over to another entity that manages the royalties. So this is thinking about not just that you get royalties today, but you understand your copyright lasts for your life as the artist plus 70 years. And so you're accounting for what happens to the royalties from your particular copyrights 70 years after you pass away. That's a legacy sort of building. That's a way to think about monetizing your copyrights for your artwork in a way that can help generations that are to come. Definitely in the legacy building or I won't be exploited zone. So quickly, what are some of the major contract terms? And I'm coming to a close here on some of these things for art contracts, and we'll go quickly to negotiation. But it's what we learn in grade school: who, what, where, when, why, how. Right? It's who's doing what are they doing, where, how, and why. Payment terms and payment schedules, very important. I can't tell you how many times I'll get a contract that does not have a payment term. It does not have the dollar amount or when the artist is going to get paid. Artist says, oh, it's sitting over there. We talked about that. It's in an email, but it's not in the contract. That's a red flag. So you want to make sure that those terms are in the contract. Again, the summary of your actual agreement, I won't belabor that point, but it's not like a sheet of paper somebody got from online and then they send it to you. It's what you actually talked about. And what happens when things go sideways? How do you resolve disputes? And there's like the list of the boring terms, the things that people kind of glaze their eyes over when they get to page 3: indemnification clause, limitation of liability, force majeure, like what happens when there's a pandemic, things like that. Those typically are the boring terms, the ones that people kind of gloss over, but they are important if something goes sideways, like a pandemic. So intellectual property management is important, not just the IP provisions, but how is the intellectual property managed? There's a difference between owning the copyright and having a license to use the copyright. So maintaining your copyright ownership is important. Licensing your intellectual property rights. There's something called the Visual Artist Rights Act. This is a function of statutory law at the federal level that gives artists for certain work what's known as moral rights over their art. So if the art is damaged or something happens to it and you want to kind of remove your name from that work of art, you can do that under Visual Artist Rights Act. You can also prevent the destruction or mutilation of your art under the Visual Artist Rights Act. Very important for muralists. There's also resale royalties. This is the idea that if you sell a work of art today at one price and then that art gets sold on the secondary market later on, and there's an increase in the price, the resale royalty says that you get a percentage of that uptick, the difference. There are artists who are in a position of more power, and they are starting to especially try to negotiate for these particular royalties. But it's the way to think about your intellectual property. And you have relationship management, the scope of the relationship and the services provided. And so quickly, because I know we're like coming up on the hour. So quickly, in terms of negotiation, it's, there's all these books about negotiation. There's different approaches about negotiation, but really to me, it kind of boils down to this. This is like the main thing. You have to have the right mindset. It's your posture. It's like literally how you sit. Like it's your posture in the negotiation. If you come into the negotiation thinking you're a starving artist, thank you so much for talking with me. I'm so happy that you guys called me because otherwise, I wouldn't be able to do anything. I'm so grateful. I'm so happy. But it starts to get to a point where you're sort of decreasing your value. 9 times out of 10, you're going to be exploited. You're going to agree to something that isn't in your best interest. And typically your mindset, what I found is it follows this continuum. You have the point in time where you're sort of generating ideas, you're deciding if you want to move forward, you're in the creation stage. So if someone approaches you in that stage, you tend to act differently than if you're in the building stage of your art practice, where you're trying to have more sustainability, you're investing in infrastructure. That's a business way of saying that you are getting maybe some standard agreements. You're being very circumspect about who you enter into agreements with. You're starting to think about things strategically. Then you kind of shift to the point where you're protecting and you're trying to grow. That's more on the legacy side where you've said, wait a minute, I want to support myself full time. I want to be able to do this work on a full-time basis, not on a part-time basis. You're thinking about things in terms of how to protect yourself and how to grow it. So that's typically the mindset. But some of the things that I work with my artist clients on in ways that we kind of think about it is this. And this is like 10 things that you can think about when you're negotiating. Number 1, you could be excited, but don't agree to specific deal points. Meaning if you're in the call, you're in the meeting, they're talking to you about the project, you can be super excited. You can be super grateful, super excited. This is wonderful. But when they start talking to you about aspects of what they want you to do, don't just agree to things without getting a full picture of the scope of what you're working on. Artists do this all the time because they're excited. So you can be excited, but don't agree to things until you get all the deal points. You get an understanding of the particular project or the particular opportunity. you can get information, right? So asking questions is important. But there's a couple sets of information. You get information about the deal, and you also get, the deal points, the specific aspects of the contract. But you also want to get information about the motivations. Why did that particular company reach out to you to do a mural? What is it that they're trying to accomplish with a mural? What's the long-term plan? How do they typically work with artists with things like murals? That's just an example from a mural standpoint, but you want to understand their motivations and who's in the room, who you're talking to, and why they're interested in the particular opportunity. Same thing for galleries, right? You want to get information about the deal, but you also want to know, what is this gallery's mission? How do they see themselves in the life how do they see themselves in terms of what they are doing for the artistic canon, or how they work with artists? That's very important to understand people's motivations. um, you want to understand the value proposition of the deal. This one's a little bit harder to discern, but after a while you'll pick it up. There'll be people who will approach you for opportunities, but when you run the numbers, if you will, if you look at how much time, for instance, it takes you to do something like a mural, you take that and you weigh that against the cost of what they're wanting to pay you, then sometimes the value proposition changes. So you just want to think about it in terms of, and that's a business term. Value proposition is a straight business way of thinking about it, but it's useful because it can help you avoid agreeing to things where you're really not getting paid. You want to resist entering into the creative process before you ink the deal. Otherwise known as stop giving away your intellectual property for free. This is a very common thing where the artist will be excited and then they'll start, let's say in the design process, they'll start coming up with ideas, colorways, collections. They're giving all of this intellectual property away for free. They're having all these conversations with, let's say, the marketing people, but there isn't a deal. There's no sheet of paper with anything about what is being discussed or what the parameters are of that relationship. So you want to resist doing that. You want to get something in writing, even if they don't do contracts. Again, an email that has the major elements of a contract, or at least has a description of what's happening and how you're going to get paid, who's doing what, is very effective. Even if they refuse, if you will, to give you like a separate contract. Also, you want to resist artificial time or response pressure. This is the classic, oh, we'll send it to you. We'll send you the contract on Thursday, but we want to get started on Monday. That is a negotiation tactic from the other side, because they want to reduce your likelihood that you're going to get counsel or get help or read it or think about it or ask questions. That is typically artificial. It often takes a week or 2 weeks to actually negotiate the deal points that are favorable. There are some licensing agreements that I've worked on for 2 months before we get it down to something that makes sense for the particular artist. So you want to resist that artificial time pressure. You want to monitor and manage your own ego. This might be counterintuitive, but where this comes in is where the artist is just they're happy that the other party is speaking with them, but then they start to overestimate their own power in the relationship. And when that happens, the artist doesn't ask the questions they need to ask. They start agreeing to things that they shouldn't agree to too soon. It's more so that they're operating off of their ego than they are thinking strategically about the transaction. And that's something that you want to monitor. Don't confuse niceness with the lack of exploitative intent. I say all the time, people are nice until they aren't. I've seen many situations where people are like really happy and it's really wonderful. And then one thing down the line, happens, and all of a sudden that beautiful relationship that you thought that you had, like, just kind of crumbles or falls away underneath your feet because the other side is wanting to do what's in their best interest. And so what I found is that when you're negotiating, when you keep in mind that they could be as nice as they want to be, but they're negotiating in their best interest, you need to be negotiating in or thinking about this from your best interest. And that doesn't mean you are mean. It doesn't mean you don't collaborate. It doesn't mean that your intentions aren't good, right? It doesn't mean that you bring acrimony or confusion into the conversation. It's just understanding that at the end of the day, if something goes sideways, they probably will not be on your side. And so that can be helpful to, thinking more strategically about contracts terms. You want to evaluate every offer, every deal, every opportunity based on your strategic plan. You know, not every contract that comes your way is something that you should do. Um, and it really doesn't matter the money, right? Sometimes people think, well, if it's a lot of money, I should do it. I typically will ask my artist client, does this fit in your strategic plan? Does this fit with what you're trying to do with your fine art practice? Does this fit with your specific goals for your commercial art? Because if it doesn't fit, then let's take a look at maybe how to change the contract so that it does fit. Or maybe it's something that you just need to pass on. So you want to make sure it fits your strategic plan and get counsel. Of course, right? Seek counsel from an attorney, but also there's a lot of information in the community, right? There's information. If you're a muralist, you want to talk to muralists. If you're someone who's like doing your first major commission, you want to find another artist who's done that. At least get some information from the community about that particular deal. Or you may get some intelligence about the particular party, right? You may have some intelligence about the gallery and the gallery relationship. So it's perfectly okay to get counsel, right? Get information from these various sources, because that can serve as a form of protection as well. Let's see, we're right up at 6:30. So I'm gonna kind of go through these couple of slides very quickly, but essentially what you see in bold are the pro artist terms of contracts. These are typically the things that I'm working on and negotiating pretty much on every single contract that I work on with artists, no matter what type of contract it is. Gallery contract, commercial art, license, their internal contracts. It's making sure that you understand the difference between, for instance, you owning your copyright and you licensing your copyright. What I'm finding is that there are more contracts coming from like, major brands, or coming from like manufacturers that say that it's a license agreement. So it's entitled license agreement. It has the word license all throughout the document. But when you actually read the contract terms together, you find out that even though they're using the word license, they have language that basically shifts and transfers the ownership of your copyright over to them. And that's problematic, because you can't just rely on the fact that they use the word license. You actually have to read it and understand how copyright works and the difference between you maintaining your ownership versus licensing out the copyright. Limited scope engagements tend to be more pro artist, better for artists, because if you limit the scope of the engagement or even the term, what you're doing is you have more, you see here at the bottom, artist control. You're saying, I'm engaging with you, art consultant, for this limited amount of things, or this limited aspect of my market. And I'm giving you the ability to work with me at this limited basis and for a limited amount of time. And that's a practical thing to do, because first of all, you may not even know if you really want to work with this person. But limited scope engagements tend to work better for artists, because it gives you the ability to, number one, test if the other party is actually someone you want to enter into a long-term relationship with. And then also you can then, take those rights and then enter into contracts with other people. So a classic example would be an art consultant that has East Coast versus West Coast. That might be something that you want to think about if you're working with consultants outside of a gallery relationship. And there's ways to sort of carve out the world, if you will, when it comes to geographic location. You may have a consultant that's selling your large scale works because they have access to those types of collectors. And you may have another consultant that's selling your smaller scale works because they have access to those collectors, right? So you're limiting the scope of those engagements so that you can maximize the relationship. Non-exclusive terms tend to be more pro artist. Same logic in that if something's non-exclusive, you have more ability to, enter into contracts with other people, or take maybe even the same copyright and, for instance, put it in a different medium and sell it, right? So you may have your art that's applied to something like wallpaper versus your art that's applied to something like tile. Those are different mediums. And so if you manage the exclusivity, then you may open up other income streams just based on your understanding of that word, exclusive versus non-exclusive. it's definitely a pro artist position where the risk is absorbed by the other party. The risk, when I'm referring to here, is the risk of the transaction. Person paying for insurance, person paying for the shipping and transportation of the art. Those types of things are all like risks, meaning there are areas where things can go sideways. So the more you as an artist can shift the risk to the other party, the better off you are. That means it's not on your side, which is on the opposite side of the slide. And really that all sums up into artist control. The more control the artist has over their own copyrights, their own image, who's representing them, what they're doing, and also, what ultimately what decisions the artist can make like on their own. Typically contracts that are like focused on the areas that you see on the right side of this slide are contracts that inherently are more pro artist and they're in the better interest of the particular artist. The opposite is true. We're kind of running out of time. I want to get time for questions, but I won't go into like why the opposite is true, but just like flip it on the other side. Of course, the other party wants to own your copyright. They want the most expansive scope possible, like the universe. They want things in perpetuity, for instance. Everything they want typically is exclusive, so you can't work with anybody else. They often will push the risk over to the artist, and they typically want to negotiate to have more control over what happens. So those are like the main issues that I see when it comes to negotiation with artists and the difference between those pro artists provisions and ones that tend to be more on the other side. And I am, advancing to the last slide. So these are some simple ways to protect yourself. And I know there's a lot of information, but it kind of boils down to get things in writing. A well-drafted and a well-crafted email or the difference between thousands of dollars in litigation to try to, enforce a contract or to try to, get something straight that's gone, a little sideways. And also when you have something in writing, it's something that you can refer to. It's a way to document your conversations. And it can even be something like when you're having ongoing conversations, just summarizing the conversation that you just had with the person can be helpful in getting something in writing. So email is very helpful for this. I typically will, when I'm working with artists, if they develop a procedure where they're doing business via text message, I typically try to shift them to email. Why? Because if something goes awry and you come to me and say, hey, Sammetria, can you help me with this issue? This person didn't pay me. First thing I'm gonna do is ask you to take a screenshot of every single text message that you sent over the course of the relationship, PDF all of that and send it to me, because I have to review all of the conversations. And so it's a lot easier to do that if you have things in email versus if you have things in text message. And so that's just the one caveat about documenting conversations. If you're doing a lot of business via text, it's a lot easier if something goes wrong if you have that stuff in email. You want to negotiate favorable payment terms. You want to preserve your cash flow, particularly if you're doing agreements. But at this point, I don't want to like gloss over it. You can negotiate more favorable payment terms. You can negotiate on your behalf. You can ask questions. No matter how much power the other party has on the other side, or how long they've been in the marketplace, or what they tell you about how much they know about what's going on, you still have the ability to negotiate. But the payment terms tend to be the ones that cause the most issue, particularly when it comes to artists of color, because the impact of someone not paying on time may be different for artists of color than other artists. They may have, for instance, access to capital that's different than maybe artists of color. So an example would be something that I worked on with the Art Commission on the municipal side, where there are artists who are able to go and get like a friend and family loan for the materials to do the work. And so then when they're working with the municipality, they can do the work and then get paid at the end when everything's finished. Why? Because they have access to capital to pay for the materials and to kind of float that project until the project is done. Well, if you don't have access to capital, progress payments are really important. Money up front, money during a certain time period in the contract, and then money after you finish the project. So you kind of like think about things differently based on your own position. And you want to think about the worst case scenario. I know it's hard. You know, you want to be excited. You don't want to, like, for instance, start manifesting negativity into the deal. But you do want to take some time to say, wait a minute, what if the worst case scenario happens? How do we deal with it? And that's when things like the boring contract terms, boring contract clauses, or even having things like insurance become very important. So that's it. Again, I'm was concerned about going over because I could talk about this all day long. I know we have some people that are still hanging on. So I'm open to asking questions. I know we're a little bit over, Tatiana, so I don't know like the protocol there. But yeah, this is how you can get in contact with me. All of my social handles, telephone number, email address, all of that. So if we don't have time to answer questions in this format here on the Zoom call, certainly reach out to me and I can see what I can do. But thank you so much. And I hopefully this information was helpful and that it shifted maybe your mindset or answered some questions that you may have had about contracts in general, what should be in them, what you should look out for, and then ways to protect yourself in negotiations.
Man, thank you so much. This was extremely helpful and holy cow, so much information. I know that I was also like writing things down furiously while you were talking as well, because of course, like this also applies to BlkArthouse and what we're doing as well. So as long as it's okay with you, Sammetria, would you mind sticking around for a couple more minutes to answer questions?
Yeah, absolutely.
Cool. So I know at least DeMarcus has a question. If you want to speak up, DeMarcus.
It was about the Bill of Rights. Oh, okay. When you spoke about the Bill of Rights and about, the Bill of Sales. Sorry, the Bill of Sales. Would that be the artist's responsibility to have the buyers to have that in the contract, or would that be the gallery's responsibility?
I typically will ask the gallery to provide that. It's
okay.
Depending on their process, there's a way to do it that, you have the certificate of authenticity, and then the bill of sale sometimes functions as, it looks like a receipt that's kind of attached, that you can detach. So that's one way to do it. There's other bills of sale, like the kind of the standard, there's like an agreement. It's like at least a page long. So there's different ways to do it, but it should, in my opinion, the gallery is in the best position to get that signed with the collector, because they're the ones that are managing the relationships with the collectors at the initial sale.
Okay, got it. Thank you.
Does anybody else have any questions?
Hi, can you hear me?
Yes.
Okay, perfect. First of all, thank you so much for doing this and for sharing this and for putting this on. Yeah, it was like super helpful. I guess my main question at this point, I'm pretty new to the like contract aspects of it, of like doing art professionally. Are there any other opportunities to be learning more about this kind of thing in the future, or can I keep an eye out somewhere for these things?
Yeah, I would say certainly, Tatiana has a very extensive, list of workshops that are planned and coming up. And also just the work of BlkArthouse to empower the community. So yeah, I would anticipate there being more presentations and more information. The breadth of the topic though was so big. I mean, I could have spent an hour just talking about a gallery contract. Especially when it comes to some of the state specific law and like what that means. So there are some nuances with some of the types of contracts, but yeah, there's definitely I would just kind of defer to Tatiana on that. I mean, I could do a presentation on just a gallery contract. I'm happy to do it. I probably just sign myself up for it, but yeah, I would defer to Tatiana.
Yeah, exactly. Yeah, I mean, Sammetria has been so gracious today, and then will be coming back in the future for other seminars that we do. And just to explain a little bit about us for those who are involved with BlkArthouse. So BlkArthouse is a for-profit enterprise that is dedicated to Black artists and the empowerment of the artist community. So we generally put on these workshops and seminars in order to educate, because as Sammetria talked about a lot during her presentation, not only are artists, and particularly artists of color, just have a lot less access to these resources and been excluded from these conversations. So we are trying to be a bridge for that and educate our artists, so we are able to actually build a Black art economy. So definitely stay alert for our social media. And then we also have a community newsletter if you want to go to BlkArthouse.com, where we if you want to do an artist sign up, that's where we will usually send those alerts out as well.
That's awesome. Thank you so much for sharing. It was really well done, really well organized. Yeah, thank you so much.
Awesome. Thanks for the feedback. And I do post on my Instagram channel for my firm. So Goodson Law, that's my firm. So yeah, I do post like little tidbits and things like that on my law firm IG. So yeah, follow me there as well.
I have a question. Can you hear me? Yes?
Yeah.
Okay. I do a lot of sales through my studio and through a studio visit. Okay. Mm-hmm. So if I'm doing a studio visit and a person says to me, can I take photographs of these paintings? What is your best advice as a best practice of saying, yes, you can, or no, you can't? I'm always nervous because I don't know, how good is this picture going to be and what are you going to do with it? I mean, even if it's I've had people who were friends who I felt like, I don't know, I mean, at a certain point you have to say, okay, here's the line, friendship is over here and business is over here. So that is one question I had. Also, I kind of made a dumb mistake by letting someone take a piece of art, pay for part of it, and say that they were going to pay for the rest of it later. And then when later came, they kind of like didn't want to pay. So now I didn't have any contract or anything with that person, but is there a way that I can, I'm looking at all of these laws you're saying common law and tort law and whatnot. I mean, would that apply to a case like that?
Yeah. So to answer those are great questions. To answer your first question, I am conservative in that what I typically advise my artist clients to do is to control the images of their artwork. So for a studio visit, it's developing comfort with saying, no, you can't take a picture, have a reason why. And then though what you can do is send them or offer them like a link where they can view, high res images of your work. And that is more helpful to facilitate, for instance, like a sale or a purchase than just like them quickly snapping a picture. The thing is that it's hard to do because there's a tension between wanting to build a relationship with a potential collector and like having this sort of like easygoing, like, you take a picture. There's that tension versus the very real threat of someone, as nice as they are, taking a photograph and then doing like uploading it, or even if they're like, oh, I visited the studio and they post it on Instagram, the way that your work is depicted may not do it justice. And even though they've given you a shout out on IG, you might not like the way it's portrayed. So it's hard to do, but just developing, if you can, developing a methodology for just decreasing the amount of photographs that people are taking in something like a studio visit, and just trying to redirect them to an environment that's conducive to sales, like a password protected link where they can view images of your work. Yeah. Now I will say this, that tension between what I just mentioned, like wanting to be kind of like nice versus like just shutting people down, that changes completely the moment your work is infringed upon. The moment someone takes your photograph and it ends up on some t-shirt, like a photograph of your work, and it ends up on a t-shirt or ends up on something that you didn't authorize, that discomfort with telling people no, like, disappears. So that's what I've found. you know, after the fact, when something terrible happens, typically the angst that artists feel about trying to control their work and control images goes away, because you're in a situation now where, you know, you have to go talk to somebody about getting some product off the market that has your image. So that's one way to think about the photos. To answer your question about the work of art and the pay later, and they didn't pay. Yeah, that's definitely, like, because you don't have a contract, what you would have to rely on are like the common law and maybe the statutes of your state to swing in to provide some sort of like relief to you. But it's kind of like a basic thing that, again, like, what's the contract? Offer, acceptance, consideration. They offer to buy your painting. The terms were they can take possession of it and then they can pay later. There's a difference between possessing something physically and having the title to it. Right. So there's areas of law that say until final payment is made, you still have the title. Okay. So just because they have the work doesn't mean that they have ownership of the work. Okay. What state are you in?
I'm in Maryland.
You're in Maryland. If you contact me via email, I will point you in the direction of a Maryland attorney that may be able to help you with that. That's a state law issue.
Okay.
Yeah. And it may be resolved with what we call like the demand letter process, where someone sends, it's kind of like a nasty gram to the other party and just lays the law out. This is what's going on. This is the law. This will happen if you don't do X. It's a nasty gram. And then that typically gets some movement. Now, I mean, if it's a friend, if it's someone that's close, of course the approach is different, but oftentimes a call from an attorney or a letter kind of shifts things a little bit. But yeah, that's a state law, kind of common law. That's where you would find the source of your relief on that.
Thank you. Appreciate you so much.
Yeah, absolutely. Absolutely.
Any more questions? Gotta have that.
If there aren't any more questions, my disclaimer is nothing I said was legal advice. It's all information. So
I will sneak in one more question if I could.
Sure.
Thank you so much. So I'm actually based in Hawaii, which, like, you know, is a state, but it's not a state because it's an illegally occupied nation. Like, you know, just, yeah. But do you have any connections, like, in this neck of the woods, or any others, like, in the Pacific that maybe do similar work, or folks that you maybe look up to, or others that I can maybe get connected with out here?
No, not directly, but it's not something, I mean, it's something that I can kind of like figure out. I would probably have our team kind of take a look to see what resources are available. So if you send me an email with what you just said, but in an email, I can kind of forward it out to my team and we can see what we can find. I will say though that, you know, even though, well, I will say that there's a set of like international law that comes into play, similar to the things that we talked about, but there's various areas of law that may be useful to you for either managing your transactions where you are, or dealing with disputes, or dealing with really even people in other places. So yeah, just email me with that specific question, the specific territory, and then we'll see what my team can come up with.
Okay, that's awesome. Thank you so much.
Yeah, absolutely. All right, any other questions?
All right. Well, thank you so much, Sammetria. This was, like I said, it was amazing, and really, really looking forward to having you back at our later seminar.
Yeah, absolutely. I'll be talking about the art ecosystem. So it kind of takes it up a level from here. You get an understanding of what's happening and maybe where you may fit in as an artist or a creative and what's happening in the entire ecosystem. So I'm looking forward to that.
Awesome. All right. Well, thank you all for being here and listening, and have a good rest of your night.
Thanks, guys.
All right. Bye all.